Hello, I'm Aaron Ware, and I want to welcome you to the inaugural episode of the Reliably Intermittent podcast from Clemens Nelson and Associates, where we aim to please and are pleased to aim you in the right direction on human resources issues. For all of those of you who aren't familiar with us, I'm a regional manager with CNA, and I'm going to allow my co-host for today to introduce himself and tell you a little bit about us. Drew?
Thanks, Aaron. So my name is Drew Esposito. I'll say this is probably the most nervous I've been about doing a speaking engagement. There's no audience. I'm so used to speaking in front of a live audience. I think I've got a fail safe because I can just point to people and ask them questions and put them on the hot seat. But I don't have that easy distraction here. But what we do here at Clemens Nelson, well, first we've been doing it since 1976. And so for the better part of a half century, we've been advising employers only on the intricacies of employment, whether that be specific FMLA, FLSA regulations, labor negotiations, discipline, policies and procedures, you name it. It's kind of what we specialize in. We say, it's always better to be a master of one trade than a jack of none. And that's certainly what we do here at Clemens Nelson. And today, as the podcast is titled, Reliably Intermittent, we're going to hopefully guide you guys through some intermittent questions that have to deal with the new FFCRA issues. And I don't know, Aaron, if you want me to start us off and just kind of go with how we got here, or if you want to lead us into it.
I'll steer us into it. So as Drew alluded to there, our topic today, we're going to be diving into the wonderful world of the Family's First Coronavirus Relief Act, or the FFCRA. Specifically, obviously there's provisions in there on emergency paid sick leave and extended family medical leave, the benefits that came out in March and began in April. And I'm sure you're asking yourself, why bring that up yet again? Well, as often happens with these types of on-the-fly benefits, not everyone agrees on how they should work and be applied. So we're going to be talking specifically about one situation with a decision coming out of the Southern District Federal Court, New York, and then what the Department of Labor did to address what the court said. But I think first, just for those of you who aren't quite as familiar as others, let's do a quick reminder on what the FFCRA provides. So we all know, I think at this point, that there's the emergency paid sick leave and the emergency or extended family and medical leave through the end of the year, December 31st, 2020. The new emergency paid sick leave, or I guess it's maybe not so new now, but the emergency paid sick leave for public employers and private employers with fewer than 500 part and full-time employees at the time an employee requests the leave to be taken. Employees are entitled up to 80 hours of paid sick leave for one of 6 qualifying reasons. Let's go through those real quick. Those reasons, as I'm sure you've heard. The first one, you're subject to a federal, state, or local quarantine or isolation order related to COVID. The second one, you've been advised by a healthcare provider to self-quarantine due to concerns related to COVID. Or the third one, you're actually experiencing symptoms of COVID-19 and you're seeking a medical diagnosis. Now, for those first 3 reasons, an employee would receive 100% of their regular rate of pay, capped at $511 per day, or $5,110 for the 10-day total. Okay. Now, the other 3 reasons, as I said, there's 6. The next batch, the first of those 3, so the 4th reason, I guess, just too many numbers here. You're actually caring for an individual who's either subject to a quarantine or isolation order related to COVID-19 or has been advised by a healthcare provider to self-quarantine due to concerns related to COVID. Essentially, one of the reasons that you as the employee yourself before could get full pay for and take the time, you're actually caring for somebody else that has those issues. The next one, your child's school or place of care is closed, or your child care provider is unavailable due to a COVID-19 related reason. Or the last one, the as of yet defined other substantially similar condition specified by the Secretary of Health and Human Services. It's been hanging out there since mid-March. Still don't know what that means. So good luck with that. But that is one of the reasons. Now, for those second set of 3 reasons, an employee would get 2/3 of their regular rate of pay for that emergency paid sick leave. Okay. And this amount's capped at $200 per day and 2,000 in total for the 10 days. Now, it's key to know that regardless of the reasons, for the emergency paid sick leave, an employee is only entitled to up to 80 hours total in the aggregate. Okay. It's not 80 hours for each of the 6 reasons, but a total of 80 hours regardless of the reason. Okay. Been getting that question quite a bit. It's not, I took 80 hours to, when I was told by my doctor to quarantine, and then I got another 80 hours because the school was closed. It's 80 hours total. It's 40
Aaron,
and 40, whatever it is.
now if you're in one of the leaves that gives you the 100% pay subject to the caps, and then you exhaust that 80 hours, but you're still out, and it's still a reason, and I know you're going to get into this, it's still a reason under the expanded family medical leave, do you get paid for the remainder, or does it flip to the 2/3? How does it work?
Essentially, you're going to be paid based off of the applicable reason for the leave at the time.
Okay.
So if you're quarantined for 2 weeks personally because your doctor told you to or whatever, and you took 80 hours at that point, and then later the school closure situation comes up for you, then that one would be applied separate at 2/3 pay.
Okay.
So it's a good, I think, a fair question, one that I think both gotten. So as I said, it's a total number. It's an aggregate number. The benefit is 80 hours for a full-time employee for a part-time employee. Okay. The number of hours for that part-timer, though, is equal to the average number of hours that the employee would have worked over a typical 2-week period. And you've got a 6-month look-back period to figure that out. It's also key to know that the benefit's an extra benefit. It does not come out of any existing sick leave, PTO, vacation, or other leave. This is a new, separate, additional leave. So it's real easy to get bogged down into kind of the, what if game. And there's permutations and possibilities as how a situation with an employee could come up, arise, or you could get the question as an HR professional or whatever position you happen to be in. And as always, if you have one of those questions, I'm going to encourage you to reach out to your HR person, your legal counsel, or your consultant. But fundamentally, this one here, it's a 2-week benefit, the emergency paid sick leave, for one of those 6 reasons. Okay. And like I said, it could go in any number of ways, and we're going to talk about a few today. But that's the crux of the issue. That's the crux of the new benefit. Okay. So the extended family medical benefit, it's a lot simpler in that it's one reason. It's definitely not simpler in application. Okay. The only reason an employee is entitled to that expanded extended family and medical leave benefit is that 5th reason from earlier, that your child's school or place of care is closed, or your child care provider is unavailable due to COVID-19 related reasons. Now, trust me, we're going to be diving way into the weeds on this one later in this episode, but the school closure, child care unavailability is the only reason that this new expanded family medical leave specific benefit can be used. Okay. And employees can use up to the full 12-week FMLA entitlement. First 2 weeks of extended family medical leave are unpaid, with the remainder of whatever FMLA entitlement the employee has is paid at 2/3 their regular rate. This one again, capped at $200 per day, this time up to $12,000 total. Again, it's not a separate 12-week bank. It comes from, this is where this gets complicated and fun. This one actually does come from the existing 12-week FMLA bank available to employees. So what that means, if you have an employee that's already used some FMLA time for a non-COVID, non-FFCRA reason, that does count against any availability to be used under this FFCRA extended FMLA. Okay.
And does the emergency sick leave run concurrently with the expanded FMLA, like a standard FMLA claim?
It can. It doesn't necessarily have to. And this is one of the fun things about the way they wrote the FFCRA. So the emergency paid sick leave, we cannot force an employee to use it. They have the option to use it. We can't force them to. If for whatever reason, an employee has not used their emergency paid sick leave for whatever reason that could have come up, okay? And say the school closure situation pops up and they give you notice they're going to need this time off, And the first 2 weeks, as I mentioned, are supposed to be unpaid. They can request to use the emergency paid sick leave to bridge that gap. Like I said, they can. We can't make them.
Okay.
Go into unpaid status, they can for that purpose. But once you get through that first 2 week essentially waiting period, then that's when the 2/3 pay kicks in and the extended FMLA goes. So as we promised, let's get into the weeds. So Drew, what did New York do to kind of messy this for everybody?
Yeah, well, to be expected, I feel like with every decision that's happened in the past 3.5 years, someone's going to be unhappy with it. So it gets challenged in court. Republicans, independents, Democrats, it doesn't matter. Everyone's challenging each other. That's just the nature we live in. Right now, everyone's litigious. So in the state of New York, they took particular issue with 4 main parts, 4 critical parts of the Department of Labor's final rule. The first one being that there could be no paid sick leave, right, if the employer had no available work, right? So the New York State Attorney's Office said that is not a provision that was included in the emergency sick leave or the expanded FMLA. In neither one of those provisions was this imposed eligibility requirement in the statute. But the Department of Labor, when they issued their final rule, said, to get this, you have to have work available. Now, people thinking logically, all right, outside of the government, would probably say, if there's no work to be had, how are they on paid leave, right? So it was a pretty, I guess, expected final rule, in my opinion.
Well, and it's kind of, I think, the traditional application.
Absolutely. Like when you do it, if you think about it in any other aspect of FMLA, historic regulations at least, we can use anyone who's a school teacher, for example, who has spring breaks and these longer, elongated breaks. If you happen to have a baby or, God forbid, have cancer or something like that, and you're heading in for cancer treatment or an ACL surgery or something like that, you happen to get that surgery right before spring break, and you wouldn't have been working at school, right? You wouldn't have been there. You're not going to have that 1 week off count against your FMLA bank. The time off in the summer doesn't count against your FMLA bank because there's no work to be had. If your business is closed on a holiday, that 1 day of holiday where you're closed doesn't take a day off of your 12 weeks. So that's kind of the analysis that the Department of Labor was putting forth, and the argument they put forth to the court. They said this is the historical application of FMLA regulations. To read it any other way, you have an absurd result, and you really do. In the public sector, when you're dealing with furloughs too, think about this situation where you have everyone furloughed, and you've got 95% of your furloughed employees not making a paycheck because they're furloughed. And then 5% have a qualifying reason, one of these 6 reasons. Well, then they're going to be getting paid when the other people are not, right? That's an absurd result. Like, so to read it that way is very strange. All that being said, the court said, you know what? The Attorney General for New York, that, you guys are 100% correct. They said, this is a statutory mandate on employers. You have to provide this. There is no language in the statute that imposes this precondition of availability of work. And the Department of Labor, you do not have the authority to add conditions outside of the statute. Essentially, you've exceeded your rulemaking authority. And they vacated that provision of the final rule. The second issue, this is one where probably the Department of Labor went a little bit out into space, was the definition of healthcare provider. The Attorney General said the Department of Labor's definition of health department is just so exaggerated that it is, they didn't say this, is my own words, it'll have perverse results. And if you look at what the Department of Labor was saying, we'll use here in Ohio, for example, or at least here in Columbus, with Ohio State University, with a large medical facility, a large medical school, many hospitals and things like that. So if you work in any capacity for Ohio State, you would have been a healthcare provider. So if you are teaching, philosophy 101, the Socratic method, somehow you are also a healthcare provider because you are at an institution that has a medical school, right? Very, very strange. Same thing. If you're in an outpatient facility of a dentist or doctor's office, and then like they have custodians that come at night to clean, they would be healthcare providers under this broad definition. So the court didn't buy the Department of Labor's argument here. They basically said that you gave no explanation for this. It has no application to the law, and it would have such a kind of unwielding impact that it's not possibly enforceable. So they vacated that provision. The third issue that they took is that the Department of Labor said that employees were going to be required to have employer consent before they take intermittent leave. And this is a really, really tricky issue. This is going to be an issue that's going to be rearing its ugly head for the next, at least the next 3 months. Who knows what they're going to do if there's a new relief package and they include different things about expansion of this law. Who the heck knows? But what they said was you need the employer's permission to take intermittent leave. You need consent before you take paid sick leave or paid emergency family leave intermittently. They said there's nowhere in the law that doesn't say it. They made the same arguments the state did that they did on the first element. And the court held that we understand the Department of Labor's argument here. The Department of Labor made a very good argument that it is not in the public interest to allow intermittent leave to be taken for people that are dealing with a COVID diagnosis or are caring for immediate family members that have COVID. And that just makes sense. I mean, we have a lot of employers that were quarantining people when they were coming from hotspots and vacations, right? The whole point of these procedures is to stop the spread. And the government put on a very, very good case that you go home and you take care of your child or your dad or whatever that has COVID Monday, Tuesday, Wednesday. Your sibling can do it on Thursday, Friday. So I come back to work Thursday, Friday. After I've been in the house caring for them, it doesn't make any sense. However, the Department of Labor failed to state why that consent requirement was required for the other 5 reasons, right? And since they failed to do that, they invalidated the whole rule. So a good example would be if your child is out from an alternating school schedule, right? You're not caring for them because they're sick. So you're not risking the exposure. So what is up with this intermittent leave here? Shouldn't it be available? Is it even intermittent leave, which is a discussion we're going to have. So the court said, sorry, government, you did not meet your burden, and they vacated this portion of the rule. And the fourth and final reason that the Attorney General's office took issue with the final rule was it required employees to provide their documentation for the leave prior to taking off. They just said this is not consistent with FMLA regulations. It's not consistent with the law. There's nothing in here that says that an employee is going to have to give it in advance, and to use the same rationale that we had in number 1. You go the FMLA regulations, the history of the FMLA. If you look at it, it just says as soon as practical, right? If you are diagnosed or come down with something right away and are put in a hospital or something like that, you're not going to be able to give it in advance. It's just what happened. And you don't want an employee coming in to give it to you either, right? Hey, I got sick with COVID. I can't take off work yet, so I better come into the office so I give them my advance notice. You don't really want that to be happening on a practical standpoint. So those 4 issues, at least in our world, the Attorney General really hit a grand slam. Those were the main issues they were doing to vacate, and they succeeded on every single element. In response, however, I don't think people saw what the Department of Labor was going to do coming. but they implemented their response just here a couple days ago, I think, Aaron.
Mm-hmm.
And so what do we do now as employers now that the DOL has given their response, or I guess what's their response first? And then what do we do?
Well, and I think it's important because as Drew said, the Department of Labor is taking some action here. And as we're recording this today, the rule or rules, I guess better put, that the Department of Labor has revised go into effect. And just for reference, so just in case you're listening to this sometime not today, today's September 16th. So the rules essentially go into effect through the expiration of the law as it's written, which, as we mentioned earlier, is December 31st of 2020. They tried to address some of these things head on. I think maybe not necessarily as what the court or the state of New York had anticipated. And I think some of this, Drew, I think is the Department of Labor trying to find a happy medium on things they wanted to stick to. And I think some of the things they said, yep, you're right. Because as you were talking about there, I think a lot of, and we'll dive into the specifics here, is the Department of Labor, I think, wanted to apply traditional principles in some aspects of it and then not in others. And I think, as you've seen, when you're in front of a neutral, you get slapped. You know, when you're saying, well, we want to apply the way we've always done it over on part one, but we're going to deviate from the way we've always done it over here. Well, you better have a darn good reason.
Yeah, we want to have our cake and eat it too.
Say that again?
We want to have our cake and eat it too.
100%. So let's kind of talk about what the Department of Labor has done through their rule revisions. So let's talk about that work availability first. Basically, the Department of Labor is holding firm on work must be available for the leave essentially to be available. So if the work's not available, the leave's not available. If the work's available, then the leave's available. I mean, that's the shortest summary of what the Department of Labor did. Now, they took a real deep dive in their rule update and kind of the preamble to it and their explanation to, I think, try to address some of the concerns that the state had, and more importantly, what I think the court based some of their decision on, in that logic that, and some of that internal inconsistency in the way they referenced the rule or the way the statute referenced the rule, but they relied on those traditional principles that Drew talked about earlier, which historically, if the work is not available, then there's nothing to be on leave from, right? So if the work site's closed, or like Drew said, if the site may not be closed per se, but you are on a shutdown. The private sector company that I work with has a shutdown week. If that's not there, or I'm sorry, if the shutdown's going on, you don't need to be there. You don't need leave from something that shut down, right? So why would, it's illogical to think that you would need to be taking leave from something that isn't happening.
Yeah.
Right. So basically that's the general concept. And the Department of Labor went further to say, essentially that the court's interpretation is not furthering the fundamental concept of what the FFCRA is in light of a pandemic. And that's keeping people at home who might be infected or around COVID infected people, right? If there's no work there already and employees are already at home, then what's the purpose? What's the point? So we're not going to take a deep dive into all of the things they said, but what it boils down to is they held on to that, but they went in and tried to address, I think, some of the concerns that the court had and just explaining the logic, right? Mm-hmm. And saying, no, for all of these things, school closure is not a medical need, but it is something that is a need, and the work still needs to be there if, in fact, you're trying to take leave away from it. So they essentially told the court, thanks, but we're going to still do what we wanted to do. But here's why. They went a little further. So let's talk, I think, next about that healthcare provider definition, because I think this is probably of the four, probably the simplest change, because it's definitions. Okay. They tweaked the rule. They tweaked the definition to say, okay, yeah, we went too far afield. we don't want the English professor. We don't want the philosophy professor at a school with a medical school to apply. That's not what the purpose of the leave was. Those people should get to take the leave if they don't fit into another exemption.
Mhm.
But what they did, and I would encourage anybody with any kind of healthcare provision or who utilized this exemption to go dive into this definition and really pour over it, maybe talk to your HR person, your legal counsel, whomever, to kind of make sure that, okay, if there's a gray area with what this person does, dive into the duties, dive into the job description to make sure you fit. But essentially they've got it into different groups. The first group is anybody who's a doctor of medicine, a nurse practitioner, or other healthcare provider permitted to issue a certification for purposes of FMLA. So if an employee can go to that person to say, yes, FMLA is appropriate for this condition, then they're considered a healthcare provider for purposes of the FFCRA. Okay. A second group is any person employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care, and if not provided, would adversely impact patient care. So I think they're getting back to there again. We're in a pandemic. We got to have people available to provide these kinds of services to ensure, not just COVID related, but the other sundry medical issues that are going to crop up regardless of whether or not we're in the middle of a pandemic. So that group includes some employees who provide things like nurses, nurse assistants, med techs, things of that nature. Now, employees who do not provide direct healthcare services to a patient, but are otherwise integrated into and necessary to provision of those services. So this includes lab techs who process medical test results to aid in the diagnosis and treatment of a health condition. I think it's important to also note that a person's not a healthcare provider simply because his or her employer provides healthcare services. I mean, that's the crux of the issue, right, Drew?
Absolutely.
I think that's the deviation here. They wanted to specify you're not a healthcare provider for the purposes of the FFCRA just because you happen to work at a place that provides healthcare.
Mm-hmm. And I think this is going to have, it's a more nuanced effect between private and public sector, or, even nonprofit, I guess, potential hospitals, because at least my gut reaction was, for any one of my clients who's a health department, they're going to have to revisit their FFCRA policy. That was my initial reaction. But, critically thinking and then looking back at the law, there's also not just healthcare providers who are exempt from the law, also emergency responders who are exempt from the law. And the emergency responder definition is arguably equally as broad, but it wasn't challenged.
Yeah, it's not yet been attacked.
Right, because the emergency responder, and I can't remember which FAQ it is on the DOL's website, in the 50s, 58, something like that. It says an emergency responder is police, fire, but then it says health official personnel.
Public health personnel.
Public health personnel, not public health personnel who are administering patient care, or public health personnel who are critical to the administration of personnel, or public health personnel who are critical to the COVID response. So a broad reading, which the Department of Labor has been doing, would say a public health official, public health personnel, would be anybody employed by a public health department. And
I think part of it, Drew, because we went back and forth on this with clients as a company. I think this was kind of the dilemma when the law first came out, in that period of time before the rules came out, right before it went into effect. What's an emergency responder? What's a healthcare provider? And what are we going to do? Because, we deal with a ton of the public sector clients, as our clients. And what are we going to do if they're not exempting, public works personnel, people who have to make sure that the water's flowing, or that the lights stay on, or more germane to what we're talking about today, public health personnel that can help get out there and do contact tracing, and can help get out there and try to stem the tide on the spread of this issue by providing information. It may not be direct patient care, but emergency management personnel in your health department need to be out there on the front lines delivering this information. And if they're not available to do that, what are we going to do? How are we going to address that? Well, I think that's what they tried to address with that broad definition.
Yeah, and I think from the public health personnel too, there's something to be said about reading it broadly, because in the public sector for the health departments, which are servicing this massive need, not just COVID, right? You're talking about restaurant inspections, sanitarian jobs, going out on new builds, right? And are dealing with the septic systems and leach ponds, and they're doing all of this stuff. But these aren't places that have 100, 150 employees. So it's like, oh yeah, we don't have to classify a sanitarian as a health personnel, right? Because we've got 15 of them. You know, like most of these places only have one. So it's like, I see the broadness being necessary to still function as a society. And like, if you want people working and progress going, like people are always trying to balance the economy. Like if a restaurant isn't being inspected or followed up for an inspection, how risky is that? You know?
And I think it's important that we note that, you know, we're not here advocating. We're not here saying, hey, we got to go out and stick it to these people. We need to exempt everybody we can. That's not what we're saying. I think what's important, though, is you've got to weigh all of these competing interests. And it's like I mentioned when I went over the quick overview of the FFCRA right at the top. This is an additional benefit. That doesn't stop you from applying the things you had before. So if you have a sick leave, or if you have some kind of personal leave, or if somebody is sick, get them out of there, get them healthy, because they're going to exacerbate, make this situation worse if you've got people in there that are sick or have come into contact. I mean, you've got the tools to manage the situation irrespective of this brand new on the fly benefit.
Yeah.
Right. So I think it's important to know, just because this benefit may not be applicable, they may be excluded from this benefit, that doesn't mean you have no tools to address a situation that comes up. You just got to be cognizant of the right tool.
And it's definitely a maybe, right?
Yeah.
It's definitely a maybe too.
Yep.
I mean, this rewrite of the health provider, right, does still present concerns on the emergency provider definition as well. I just don't think people really read them. I think it's classic when legislation is drafted in a rush and passed, you know, in the midnight hour, everyone's really flying by the seat of their pants, and they're not looking at two different provisions that really work in tandem, right? You know, I think the DOL, now probably not intentionally, but if they were revising that rule, it would have been nice to see them define what public health official or public health personnel is, right? Is it everybody who works in public health, or is it public health personnel who are emergency responders?
Mm-hmm.
You know,
So,
I don't know
it comes back to taking a look at what an individual employee, what an individual job needs to be doing, and paying attention and knowing the job and knowing what the need is.
Yeah.
All right, so let's dive into a couple of the other rule changes. Let's do the easy one before we dive into the one that's probably the muddiest. The documentation issue.
Number 4.
The fourth of the ones that Drew mentioned earlier. So the issue there was the initial rule under the FFCRA rules that documentation needed to be handled prior to taking the FFCRA leave. Excuse me. The court, you know, like Drew said, it made a lot of the provisions of the thing unworkable, just illogical. And this is one of those areas where I think the Department of Labor wanted to have their cake and eat it too, that they kind of deviated from traditional principles. And essentially what they've done in this revised rule is go back to those traditional principles, and that now the documentation need not be provided before the leave begins, but rather it can be given as soon as practicable, which is in most cases when, you know, the employee is going to give you notice that they need it. And then where someone is seeking, you know, I think the most common one we're probably going to see now, other than, hey, I've got COVID, or, hey, I came into contact, I'm going to the doctor, is the school need. So I think the situation there is employees are going to still have to provide employers, excuse me, with notice again as soon as practical under the circumstances.
And
If,
one interjection too.
yep.
They still have to follow their typical notice requirements,
Policy. Yeah,
and
we
that's
still have to follow
consistent.
policy.
Exactly, and that's consistent with FMLA too. Is you got to follow your normal call-off procedures, whether it's FMLA or not. You still got to follow your employer's rules.
Yep, that doesn't change anything. It's just whether or not how to leave it. You can't wait for the documentation before you apply it.
Yes.
They still have to follow the rules, but that doesn't mean that we're waiting to say, hey, yep, you're right, that's a FMLA, or hey, that's EPSLA, because they didn't get the documentation in beforehand. But the DOL did mention that for the school closure situation, that if that leave is foreseeable, hey, school starts in 2 weeks, here's the schedule we're going to apply. At that point in time, it's incumbent to we're going to put you on notice as the employee to the employer that we know in advance that the school is going to be closed, that the Department of Labor anticipates that the employee generally would provide that notice beforehand, but it's not necessarily required. Again, it's back to what do the circumstances warrant? Because if the school, schedule changes overnight, as has been the case in certain jurisdictions, and they call you and they follow the otherwise policy rules and procedures applicable to the situation for the call-in at that point, we still don't have to get that notice in advance. So let's go back to that intermittent issue because, that was, I think, one of the more significant issues it read to me that came out of that case in New York, that the Department of Labor's blanket requirement that an employee have employer consent to take intermittent FFCRA leave. The court there, the big issue, like Drew said, they just hadn't explained why. I mean, in a nutshell, the Department of Labor. So as was the case with the work availability situation, the Department of Labor is essentially sticking to the original rule, although they've gone further to explain it. I think they read that to mean, hey, okay, it's not necessarily that we're doing it, requiring employer consent on intermittent leave, just that we didn't explain it very well. So if you actually go and dive into the rule itself, I'd say 2/3 of that is them explaining why intermittent leave needs employer consent. So the rule, the FFCRA itself does not specifically reference intermittent leave. So traditionally that gives, the regulatory agency here, the Department of Labor, a lot of latitude to kind of fill in that gap. So what they've done, the Department of Labor in their rule, is that they went back and fell on classic FMLA rule application and regulation to provide that intermittent leave is only for certain qualifying reasons. Where intermittent leave is medically necessary, or where the employee and the employer agree to an intermittent leave arrangement. So since the situation for this is only for the school closure issue, they really talk in the rule about this isn't a medically necessary issue because it's only for that school closure issue. Nobody's sick. It's that we just have this new application of an old rule or an old law that is designed to address the school closure issue, and I just can't physically be at work because my kid can't be at school or daycare or whatever. So the Department of Labor really went back to those classic FMLA regulations that require when that kind of need for leave is foreseeable, it's got to be scheduled in a way that's minimally disruptive to the business operations. And that's where they really relied on reinforcing that requirement for employer consent. Okay.
Absolutely.
So essentially that's a long-winded way of saying employer consent still required. Now they did kind of apply some, I'm not going to quite call it wacky, Drew, definition to intermittent, but maybe you can dive into a little bit of kind of how they juxtapose what's intermittent now versus what's not intermittent.
Yeah, I think the strangest thing is they use two situations that are pretty much exactly the same. And they come with
operationally anyway.
Operationally, they come with two different results. So the example they gave where you don't need permission because they're saying it's not intermittent is if a school is on a hybrid work week or a hybrid school week. So let's say you have school Monday, Wednesday, Friday, and you don't have school Tuesday, Thursday. They're closed Tuesday, Thursday. or it's not that they're closed, but that is not your child's attendance day. So
Yeah, they're
they are
closed
not,
for your child.
they're closed for your child. The Tuesday and Thursday of that week are each separate instances, right? And therefore it's not intermittent, right? There's a singular day. Now, if your school is closed for an entire week, but you have the same work schedule, and so let's say I can manage my children Monday, Wednesday, Friday. I've got childcare from my spouse or grandparent or whoever, but I still need to use it Tuesday, Thursday because I don't have childcare or whatever. That is intermittent leave and is not permitted unless the employer approves. Now, this is where it's really strange because usually an employer is trying to get employees back to work. So they're saying, hey, you can have Tuesday and Thursday off, but I'm not approving it on an intermittent basis. You can basically have the whole week off. And the employee is saying, but I don't need the whole week. How about I only use 2 of my FMLA days or my EFMLA days? If I'm an employer, I want people coming to work. I'll only make you use 2 days. Maybe that's just me, but that seems like the practical reason. And when you read the DOL guidance, at least spattered probably 100 times through all these rules are, we encourage employers to be liberal in their interpretation and liberal in their application and liberal in their granting of you.
Work with your employees. Try to make something work for everybody. I mean, that seems to be the message.
Yeah, it's all over. So
now it's important to know, even though they tried to muddy this, I think, with some of this new revised rule, the situation is simply if the school is closed to your child and you have no other suitable care option, EFMLA is available.
Mm-hmm.
It's just a matter of essentially how much.
Correct.
And if you're on that hybrid schedule, I think the kind of not counterpoint, but going a step further, if your school's on a hybrid schedule, then that means that Tuesday, Thursday that Drew mentioned earlier, between the 3 separate instances of not intermittent, separate insular instances of FMLA, then the person has to be at work because EFMLA does not apply.
Correct.
So like Drew said, you're dealing with functionally to the operations of your business, to your agency, the same amount of time that your employee could be there, but you're going to have to treat it differently based off of essentially the facts that are being presented to you and what kind of school issue is being presented to you.
Yeah, I truly do. There's a little bit of doubt, but I do think the liberal interpretation is the way to go now. Especially, it really appears to be kind of a do-nothing Congress, right? Nothing has been able to get done. This law expires December 31st. Mm-hmm. So if you want to be an employer, in my opinion, that wants to take more strict, interpretations and go, I'm going to make you burn it all, right? It's like you're opening yourself up to potential challenges, whether they're, founded or not. All we have to do is withhold this storm through December 31st. And then we can figure out what we're going to do without having the government hanging over our head with the threat of a lawsuit. Now, if they do come together in the witching hour at the end of 2020 and expand the EMFLA into 2021, well, then we're going to want to make sure we really are analyzing this the right way. And plus, we'll be dealing with an election result, and who knows if there'll be new final rules that come in.
Yeah, I mean, I think fundamentally here, the thing that you need to be doing as a manager or as a supervisor or whatever position you're in where you're making a decision, just gather the information. Don't go into any of this half-cocked. Mm-hmm. Because I know, where we are in Columbus here, there are approximately 13 school districts within, as the crow flies, 30 minutes. And they're all operating on different schedules for different employees. And that's more the norm than it is, I think, a difference or mm-hmm. not across the state of Ohio. So you need to gather the information because this is one of those unique situations where you could have two employees doing the same job and have to be, the situation has to be handled differently based off the facts that you're being presented. So you really need to gather the information to make the right decision, whatever it is that you determine it is.
Yeah,
So.
and at least right now, I don't know. Me personally, I'm leaning a little bit more towards the Department of Labor final rules. I know we got a court out here that invalidated the four of them, but that, I'm speaking personally for talking to my Ohio clients, right? It's a district level court in New York. Whether they're going to appeal, whether the Department of Labor, the DOJ is going to appeal to the Second Appellate District in New York, which still is in Ohio, obviously. It's like Connecticut and some. Right now, I would rely on what the administration that enforces the rules is going on. And I think the revisions, especially with the healthcare provider one, and their analysis of the availability of work, I think it's right. Right? It doesn't make sense that someone will be getting paid while they're off
nothing
work,
to do
when there's no work to be had, like if they're furloughed or if an office completely shuts down.
Yeah.
Like if you think about it in unionized environments where sometimes there's long waiting periods for going out of business, whether it's layoff proceedings and things like that, you could have people that are getting notice of a layoff, getting closed down, having furloughs, going through grievance processes, getting paid, and there's no work to be had because they got sick. Unfortunately, don't get me wrong, but because they got sick or are caring for someone that got sick, or they're just claiming that they need it for childcare. That's an absurd result to me.
Okay. Well, I think we've sufficiently kind of gas bagged on the new rules.
the inaugural podcast.
Yeah. So for those of you who stuck through to the end here, thank you for joining us on this inaugural journey. I think we intentionally went with the name, the Reliably Intermittent Podcast, because, we want to stay topical. We want to stay on things that are affecting everybody the most. And sometimes those things come in waves and sometimes they don't. So I can assure you that when there's something to talk about, we're going to be here talking about it. It may not always be me. It may not always be Drew, but it's always going to be Clemens Nelson. And we're going to give you the best information we can put together at the time. So with that said, Drew, thank you for joining me today.
Signing off.
Yeah. And thank you to our listeners. Until next time, goodbye.